Okay, the next item on the agenda number 4, is on Apache County. The reason why this is on the agenda is here recently we've had a flurry of emails from different parties about he said, she said, you said type of thing, and we thought it'd be good just to try to clarify. I think council has had some further conversation and such, so I thought we'd just bring that information to the floor.
Thank you, Mr. Chair, and I did spend some time looking at this again, and I want to emphasize one thing, and that is, you know from the almost year I've been working here that I may sometimes tend to go overboard and detail, and so I know it's your prerogative, I know you know it's your prerogative, but please feel free to stop me at any time if you think I'm headed in the wrong direction or anything like that. But I did spend some time looking at the presentation that we did last time. I listened to the radio show. I read the emails, at least the ones I was forwarded, that you referenced. And so I would like to kind of talk about some of the issues that were raised in those. And I also hope we can get the conversation back on track about the appropriate course of action for Jackson County. The comments that I heard from the radio show and from the emails, one was related to misinformation or disinformation. I'm not even sure, I'm exactly sure. So I resurrected the presentation that we did back in December. And I thought we're not going to go over this, but I did want to touch on some of the high points of that and effectively refute that disinformation or misinformation allegation. One thing I want to start with as well is there's a suggestion that the timing of this was somehow suspicious. It did occur shortly before the first of the year. It is correct that Commissioner C.W. Smith was leaving the board at that time, and Commissioner Breidenthal was not yet sworn in but was coming on board. And you know, there's a conspiracy perspective on just about everything that happens, but the truth of the matter is C.W. Smith was part of the board that kind of asked those questions, and it was absolutely appropriate to answer those questions before he left the board. He was part of the board asking the questions, and he certainly deserved those answers. So there's nothing suspicious about the timing. Commissioner Breidenthal has been, provided the information. I know he's had the opportunity to look at this, and so there's nothing sneaky about that. It was simply trying to do it before Commissioner Smith left. I'd also like to make it clear that the opinions expressed in that were mine. They were never formally endorsed by the board or anything else. I think there was some head nodding going on at points, but the point needs to be made that these were opinions that I brought to the board, and in fact on page 1 there's actually a specific disclaimer indicating that
reasonable minds.
Yeah, reasonable minds can differ, and in fact that this is my opinions and not specifically decisions made by the board. So as I said, I think it's crystal clear that these were simply my opinions and information that I investigated and brought in front of the board. So the presentation itself, the first part, probably about half of it, is talking about the case law regarding the legal foundations for local government control over federal lands. The thrust of that, again, is that certainly people could disagree with my conclusions. They may have a different take on what they believe the law says, but I simply quoted cases and talked about the U.S. versus Gardner case out of the Ninth Circuit and a number of Supreme Court cases. So again, they can certainly disagree with my conclusions. Reasonable minds can differ, but by and large, it's simply opinions in that portion. In short, my conclusion was that federal law is supreme, and the case law is very firm on that. Their arguments that they have raised are creative, inventive, well-researched, and politically appealing to especially people in the West, but the legal concepts have been consistently rejected by the U.S. Supreme Court since the mid-20th century. I'm reading from page 8 from these slides. So I'm actually quoting what we talked about. And that even if those arguments for local control were well-founded, they're really more about states' rights to control lands and the constitutional theories that are being talked about. They're not about local governments. And so, as I said, they can certainly disagree with those conclusions, but those were my conclusions, and I think they are supported by the case law from the U.S. Supreme Court and from the Ninth Circuit. We spent some time talking about the Apache County case and that situation down there. I basically quoted from the resolution that was passed by the Apache County Board of Supervisors, Board of Commissioners, I think it's supervisors down there. They did in fact kind of stretch their wings a little bit and basically say that they were going to do what was necessary to protect their community under health and safety. The federal response in that case, we also spent a bunch of time talking about, looking at page 12. So what really happened was, this was not the Apache County basically bringing the federal governments to its knees and doing what they wanted to do. There were actually cooperative agreements that were reached between the forest and the county. Remember, this also arose out of a huge burn, not unlike what we're seeing now in this part of the country. So that was the backdrop, is what to do about health and safety and dealing with these. So I spoke at length with the Apache Sitgreaves Forest supervisor down there, really nice cooperative guy by the name of Jim Zorns. And he basically said that they had a bunch of NEPA, basically environmental impact statements, approved and on the shelf so that they could do this work. The completed EIS work allowed those fuel reduction projects to begin quickly, but they were all done in compliance with federal law, and all of the environmental impact statements, public notice, and all those sorts of things were complied with. The Forest and Apache County entered into a master agreement, a 5-year agreement, which allowed a series of individual projects to really do the thinning type of projects that were being talked about. There was a single supplemental agreement entered into. It was a 1-year agreement. Actually, it was working for the federal biennium. So Apache County started work on an 81-acre parcel. I think I may have indicated 85 in my presentation last time. I've also heard an 89-acre reference going around, but I think it's all the same one. It's basically an 80-plus acre parcel that the federal forest gave grant funds to Apache County to do that thinning work. I put in my report, based upon what Jim Zorns told me last year, that about 3/4 of that work had been done. There was some steep stuff that was not completed, and they do have a fairly short working season down there given the weather limitations. But when I spoke with Mr. Zorns this year, he said really only about half of the work had been done by Apache County, and that's through this point as well. And Apache County has until the end of this fiscal year, September 30th, basically to get that work done, or they'll just be paid for the work that they have completed, and the balance of the project will not be completed. So that's kind of an update on that to some extent. I have some more a little bit later, because I'm talking about basically my presentation at this point. And then we went on to speak about basically the Otero County, New Mexico. So in Otero County, New Mexico, you have a similar situation where the county there passes a health and safety resolution, again, stretching its wings a little bit and saying that they're going to do whatever is necessary to take care of the issues. At the same time, in the state of New Mexico, there was a state statute adopted which kind of said the same thing. It basically was kind of a take control over the forests by the states. In that case, as opposed to the cooperative working relationship which occurred in Apache County, the feds actually filed litigation, and the litigation was seeking to enjoin Otero County and the state from taking any action in that forest. And it also sought a ruling from the court that basically the federal law was supreme and that neither Otero County nor the state could go in and take any unilateral action without the permission of the forest. So I spoke with the same person I spoke with last time. It's the basically person from the U.S. Department of Justice, Andrew Smith. Is that his first name? May not be his first name. At any rate, Mr. Smith, and he indicated that there's no decision in that case yet. That basically they're waiting for a judicial ruling, and the judge has asked the parties a few more questions. But the bottom line is they filed suit, the feds have, and said that there is no basis for them doing that, and that the counties can't go into the forests without the permission of those forests and without complying with all of the federal requirements. Again, in that particular situation, talking about disinformation or inaccurate information, I actually quoted from the pleadings in those particular cases. So I think there's nothing misleading, there's nothing inappropriate, there's nothing wrong about what's in the information that was presented in December of last year, with the exception of the fact that I know there are people who don't agree with the legal analysis, and I appreciate that, and I respect their right to disagree with my opinions, but I still maintain that the information that was provided was accurate and, frankly, it is still accurate. So I also followed up on some of the things that were stated during that radio program on Monday. And I had basically exchanged an email or two with Mr. Zorns. Yes.
Which radio program?
The Meyer Show. It was on Monday, I think. Yeah, it was Monday, wasn't it, Danny? At like 7 o'clock, I think, was the hour during which they talked about this. And there were two people there from Douglas County who are representatives from the National Constitutional Sheriff's Association. Again, I'd just like to talk about some of the things they said and then kind of respond with what my investigation following those comments was able to uncover through Jim Zorns again with the Apache Secrets Forest. So here's the short story, and I know there's a lot more to this, and I don't even want to attempt to summarize all of their positions, but this is basically the types of things that came out during this program, and they're the types of things that show up in emails I know that the commissioners see occasionally. And that is that Apache County used a public health and safety resolution to get trees cut. So it was because of this resolution that the trees were cut, and Jackson County should do the same, basically. The implication is that there's no need to comply with any federal laws. If you do this and you take action, there'll be no consequences, and you're entitled to do this. There was a reference during the radio show to 10,000 acres that had already been harvested of trees, and another 200,000 acres that were on the books and ready to go. Because the sheriff is responsible for ingress and egress, again, it's a constitutional sheriff's association, so I get that. These two were arguing that the county could use the Community Wildfire Protection Plan to log and clean within 300 feet back from all the roads, and they also indicated that they could harvest 3 miles back from the wildlands urban interface, or the WUI. And they also talked about the county should be enforcing, after Jackson County adopted this public health and safety resolution, that we should be enforcing the Northwest Forest Plan. So that's kind of the backdrop for my conversation with Jim Zorns from the Apache Secrets Forest. And here's what Mr. Zorns told me. So the 10,000 acre reference, he basically indicated that after the fire, they did in fact use a streamlined NEPA process, again, environmental impact process, to remove burned, dead, and hazardous trees near the roads that were in the fire area. And they cleaned 150 feet back from the center of the road. So the bottom line is it was a 300-foot swath. It is about 10,000 acres, but it was basically burned trees, not green, fresh trees that were being harvested. So that burned stuff was removed, and again, they were considered as dead and hazardous trees near the roads. The streamlined NEPA process included a letter to the file, but they also were required to obtain U.S. Fish and Wildlife concurrence with the health and safety need to remove those trees. So again, compliance with federal law to do that. Zorns told me specifically that this process could not be used to cut healthy merchantable timber along roadways, that another process would have to be used, environmental, perhaps a categorical exception or something like that. But the bottom line is, NEPA was complied with, and it wasn't healthy, fresh timber that was being cut that you typically think of in terms of a log harvest. The Forest Service had entered into 22 individual timber sales to cover the 10,000 acres, which is again about 150 feet on the other side of the road. These were all Forest Service contracts. Again, federal law was completely complied with, and it was not the result of that health and safety resolution filed by Apache County. It was simply dealing with all of those burned trees. The reference to the almost 200,000 acres on the books with approved projects ready to go in the next 3 to 5 years, he has no idea what that is. There's no 200,000 acre parcel that he's aware of that's true about. He did make some reference to the Forest Restoration Act. That's the number 4, Forest Restoration Act. So the combination of forests down there, and over the course of several years, there's over 1 million acres that they're talking about doing some enhanced forest on. It's a federally approved project, federal authorization to do that. But again, in the Apache Sitgreaves Forest, there's about 15,000 to 20,000 acres that would be impacted. And the environmental impact statement is in process there. It's basically out for public comment. So they're fully complying, again, with all the federal laws related to those harvesting projects. So he's not sure what the 200,000 acres is. He did tell me specifically that they do maintain about 75,000 acres that are NEPA approved and on the shelf. They're basically cleared when they're able to get through the legal process, through the sales and all of that.
Not unlike what we have here.
Not unlike what we had, exactly right. I mean, there's some approved, and then so each year he says they do about 20,000 acres of that. I asked him how many million board feet that represents, and he says it's about 50 to 55 million board feet a year that they're able to harvest. Now that's obviously significantly higher than here, but they also experience many fewer legal challenges to the decisions to harvest timber down there, and that's the real difference in terms of timber harvest, I think, between here and there.
Did you say if any of those pre-approved NEPA projects are a result of the resolution of the Apache County Board of Supervisors?
They were not. They're just on-the-shelf stuff, and as I indicated, when Apache County filed that resolution, they already had a bunch of projects on the shelf at that juncture, so it's what they typically have on the shelf ready to go when they are able to respond to either funding that they have or the ability to put those on the sales block. Yeah, right. And I don't know how many projects that represents. He just indicated about 75,000. So in addition to that, he said they also have approximately 1,200 acres plus or minus for kind of hand thinning, and that's really what that other project was with Apache County, that one-year project. But he said it's not likely that any of those are going to take place because they have zero funding to support that type of hand thinning project. So those are things that cost money. They don't produce money for the forest. They're really about health and safety sorts of thinning. He also gave me an update on the Apache County work, basically that one contract that they have with Apache County. Again, they had that 5-year master agreement in place, but there's only one approximately 80-acre project that's actually been funded. And that was money that was given from the federal government to Apache County to conduct some of that thinning work and to remove dead trees that were burned. And, as I understand it, I think Apache County was using that for firewood harvesting. And again, as I explained, they're only about half of that, half completed with that, so approximately 40 acres. They need to finalize that or finish it by September 30th, or that project's going to be over with. He indicated to me that there would be no additional projects that would be funded between the forest and Apache County until that one was done, or at least concluded through the termination. So nothing before the next federal fiscal year, it sounds like. We spent a little bit of time talking about the burn trees. I thought maybe a little bit of relevance to our situation as well, but just some statistics from there. So he did talk about the 10,000 acres, basically areas along roadways that were cleared, a shortened environmental process or streamlined process to remove hazardous trees. So that was done, again, about 10,000 acres. He said there were about 8,000 acres of burned trees that were green enough to harvest basically for timber resource. And so they are, he didn't indicate specifically, but they're basically, were in the process of that until really recently. And he told me that at that point, they were told that basically they couldn't proceed any further because even those green trees were now of no longer any commercial value. So apparently that has slowed down as well. The trees are so badly burned and they're no longer a very good resource for traditional timber harvest, I should say. So they did have about 11,000 acres of burned timber that had commercial value, but only for pellets and biomass sorts of treatment. And they were only feasible if for a pellet mill they were within about a 90-mile harvest range. They become economically not feasible if they exceed that for pellets. And for the biomass plant, they have to be within about a 70-mile harvest range for economic viability. So he indicated to me, Mr. Zorns again, that there's about 11,000 acres of burned timber that no longer have any real commercial value. And it wasn't clear to me if it was because they were outside the commercial radius, or maybe they're so deteriorated now that they really don't have any biomass or pellet value either. But again, about 11,000 acres. They said their biomass plant, in fact, had been struggling and either recently closed. Anyway, they were struggling economically and may not any longer be in place, or maybe they just recently started back up. I'm not crystal clear on that. So the bottom line is he wanted to make it crystal clear that all of the work that's been doing in their forest has been NEPA approved, either with a full or a streamlined method, and with the consent of the forest. There's none of this Apache County doing it on their own and stretching their wings and bringing the federal government to its knees and forcing this sort of activity. The sort of response that we could expect from the federal government if the county took that position is, as I described in Otero County. I think we could expect some litigation associated with that, basically saying that federal law is supreme, the feds control the forests, and the feds would argue that the county has no ability to act independently on federal forest lands, well, independently of the Forest Service or BLM. So I'd be happy to answer any questions. I'm not sure how much more I could give you because I pretty much regurgitated everything that I received from Mr. Zorns. One other thing I might point out that I'd like to make clear, when I did the original presentation, I made numerous attempts to contact the county council in Apache County and the county council for Otero County. So to be fair, I have only heard this story from the federal perspective. And I certainly want to make that clear, that this is the federal perspective on it. It's not what Apache County or Otero County may say about either of those situations. But I can tell you that certainly the documentation I've been provided, the master agreement and the supplemental agreement in Apache County, as well as the pleadings in Otero County, seem to back up word for word what's been talked about by the people that I've been able to have contact with.
Okay, thank you, Rick.
I'm sure Rick will brief us on what the Ontario County lawsuit is, once that decision is, because a lot of this, I'm sure there'll be more discussion once that lawsuit comes out.
There will be. Remember, that's in the 10th Circuit. So
It's a whole different,
it's a whole different climate in that particular court, and although it may be influential in one way or another, it would not be binding within Jackson County or the Ninth Circuit. And so we're looking at this point only for the district court decision, and then I suspect when that occurs, it will get appealed by one side or the other, regardless of the decision. And then we could look optimistically for maybe a Supreme Court ruling on some of the issues that are raised. But I think I mentioned to you in that U.S. versus Gardner case, the only Ninth Circuit case that kind of addresses many of the legal issues, not necessarily the Otero County issues, but the legal issues related to local control over federal lands. The U.S. Gardner case, the U.S. Supreme Court refused to hear that particular appeal. So that's the only law we have in this circuit regarding that issue. Well, not the only, but maybe the primary law that we have.
But didn't you say in regarding the Otero County case, there's multiple other cases either that have been settled at the Supreme Court that are constitutionally supported or have at various district courts been determined and not made it onto the court that simply already answered the Otero County case?
Yes, I mean, I think if you took a look at the briefs that were filed by the federal government in the Otero County case, you would see that there are numerous federal cases talking about the fact that the Congress and the courts have ruled strongly in favor of U.S. government control over those U.S. lands. And it doesn't mean that that can't be reversed at some point. It doesn't mean that the states can't band together and require politically a different solution perhaps, but I think the law is pretty strong and clear that the U.S. government is holding the much stronger case in that Otero County litigation.
Do you know of any one of the people that you referred to on the radio show that you heard or are attorneys?
I don't know. I mean, I've never heard them indicate that, so my guess is that they would probably wear that badge proudly in these conversations if they were. So I doubt that's the case, but I don't know one way or the other. You know, I also brought Joel. There were some questions. If you had any specific questions about NEPA compliance or community wildfire protection plans or anything like that, Joel is really the go-to guy in the office. But I hope I've answered most of your questions. I just had it here as a backup if I couldn't handle any questions you had.
No, I think the situation is because there was some indication there was an actual charge of this information, and I think you've done a nice job of clearing that up, and I appreciate that. That's what we're looking for.
Mr. Chair, I would like to say I spoke 6 or 8 months ago with the county administrator in Apache County, Delwyn Wingate. I received a fairly critical email from him the other day questioning our conversation. So I had staff look up, and sure enough, I made that phone call on February 4th of 2012. I remember our conversation. I just called him and said, "Here, you're starting to log back there, you know." And he said, "Well, yeah." And I said, "Well, you know, how's this working out? Are you getting all this timber? I hear you're getting all this timber." And he said, "Well, that's really not the way it works. You know, all the green timber that, you know," I told him, he talked about stewardship programs. To me, I don't like stewardship programs. He did, so we had a little disagreement on that. I would rather see timber going to the mill, get federal timber receipts, and I don't think they've got any federal timber receipts.
And by stewardship, I think, just to make it clear, you're talking about where the federal money basically gives grant money to deal with the thinning project.
Like the Ashland watershed.
Right.
Thing, yeah.
Exactly right. And as I said, that's really what happened in Apache County relative to that one supplemental agreement / contract that was entered into between the feds and Apache County. It was that sort of funding and not real true timber harvest with
Timber receipts.
commercial timber receipts, correct.
So are you two texting each other? Or?
no,
Oh,
sir.
I just wanted.
That would be improper.
Well, yeah, that's right. Okay, was there any other questions?
No.
Okay,
Thank you very much.
all right, thank you, Rick, I appreciate